It is my pleasure to introduce our first speaker for the afternoon, who is Mark Hauck. Profound changes have occurred over the past 2 decades in how we communicate. Email, social media, texting, and Twitter did not exist when many of us became lawyers. These new technologies provide trial lawyers with opportunities that allow us to mine previously non-existent electronic data for our clients' benefits. Please welcome Dykema's Mark Hauck.
Thank you. Customarily, after the lunch break, the organizers try to find a truly dynamic, energetic, and compelling speaker. Unfortunately, that speaker is not available today, so you're stuck with me. When I was asked to speak for this year's program, I was searching for a topic that was both pertinent to my personal practice as well as being, I hope, useful to the general counsel that are in the audience. Proving or defending a sophisticated case in the 21st century is very different than it was when I began litigating product liability and med-mal cases over 30 years ago. Most evidence, though, then and now, is in the form of some form of communication between people, whether it's a contract, an engineering report, a medical record, or a letter. We have always dealt with such evidence as litigators, but what has changed is that we now have a virtual real-time record of people's thoughts, often stripped of the prudence and reflection that used to accompany most written communications. That's a game changer. In fact, profound changes have occurred over the past 2 decades in the manner in which we communicate with each other. Email, social media, texting, and Twitter did not exist when many of us became lawyers. Today, these forms of electronic communication have significantly displaced traditional correspondence, telephone calls, and even face-to-face meetings as the primary means of exchanging information. This sea change requires lawyers to educate their clients about the risks that these new forms of communication pose, while also forcing litigators to understand and exploit the technologies to allow us to mine electronic data for our benefit. AOL, Prodigy, and CompuServe started 20 years ago. Think about that, only 20 years ago. To many of us, that seems like just yesterday. But for the majority of the people working at your companies, it has always been a part of their adult working life. These services automatically provide users with an email address and the means to send and receive email. By 2000, approximately half of the Americans were using the internet in some form, and most had established email accounts with Hotmail, Yahoo, and an assortment of other free providers. It was inevitable that this use of email would eventually invade the business space, and in fact, it has become ubiquitous. Today, email is by far the most common form of business communication. My research indicated that in 2013, there were over 950 million business email accounts, and over 100 billion emails were sent each and every day. Each one has the potential to make or break the cases that we handle. It's apparent to all of us that in the last 20 years, this technology has transformed the way we communicate, and the rise of the digital age has greatly accelerated that process. Following the footsteps of email, we came upon the world of social media in 2006 with what transformed from a university dating service essentially became what it is today, with millions and millions of users around the world. It provides individuals with the opportunity to share their most inner thoughts, sometimes accompanied by photographs and video. Social media, though, is not just social. It has huge ramifications on businesses and the inevitable disputes that arise within businesses, many of which find their way into the courthouse or an arbitration forum. The credibility of a trusted employee who is the epitome of prudence and decorum at the office can be destroyed or at least impugned by the Friday night rant or the spontaneous post on his or her Facebook account. Twitter, Instagram, and an assortment of other messaging services have arisen since then as well. All of these electronic communication forms have transformed the way we communicate. What makes them particularly dangerous is their spontaneity, their casualness. Taken together, email, social media, and these other communication media have profoundly changed the way human beings communicate. Recall my earlier point that a lot of the evidence in our cases is one form or another of communication. And this communication today is recorded. Today, most of the communications that we have are saved and retrievable. The phone call, water cooler chat, or in-person conversation have largely been displaced by some form of electronically recorded communication. I was in New York yesterday attending a meeting with several attorneys with whom I'm litigating a significant case in Michigan. The dispute involves the sale of a business for several $100 million. There is a lot at stake. The mood in the room was sober. We spent several hours reviewing the evidence that had come out during the discovery process and the document exchange. We were looking for items that both supported our case and that potentially supported our opponent's case and their theories of liability. We looked at over 100 documents. Most of them were emails. The effect of this is profound in terms of the off-the-record statements that are now electronically recorded. Every comment, whether serious, off-the-cuff, sarcastic, disingenuous, or otherwise, is recorded in black and white. The tone of the communication is often difficult to decipher. It can be misinterpreted and taken out of context. And what you say can and will be used against you. But still, today, people use these electronic communications as if they were ephemeral. They're not. They're here forever. In the case I was discussing a few minutes ago, we were not dealing with young, immature teenagers talking about high school crushes. We're talking about sophisticated business people, many with graduate degrees, who send each other messages containing their most critical thoughts about a multi-hundred-million-dollar transaction and their roles in it. If they thought for a moment that they would be confronted with these emails under cross-examination, they would never have written them. But they did. And in 2015, they still do. The consumer's use of email was initially casual and among friends. That habit does not translate well into the business use of email. Troublesome admissions can be made, as was demonstrated in the Apple case, where emails were used as a profound means of establishing liability. Quick communications does not always equate with effective communication. Thinking out loud is not helpful in a litigation context. Joking and sarcasm can easily be lost in context. The users of a company's email must be educated on proper and improper use. Emails belong to the company, not the sender or the recipient. Emails can be reviewed, emails are preserved, and emails are subject to discovery. Compose emails as if they were going to be read by the company president, your competitors, or to a jury. Make sure your people know that CCing counsel does not necessarily make the email privileged. Teach them not to make admissions. Be careful who they send them to, and by all means, avoid reply all. Take care when sending attachments, and proofread. If I were a general counsel, educating my company's employees and management team on this subject would be the top of my list in terms of protecting my clients' interests. Simply sending out a memo or an email to your people is simply not enough. People have to be confronted with their own words in writing, or at least examples from others, in order for them to begin to appreciate the gravity of how and what they communicate and its effect on the business. I recommend 5 steps. Formulate, communicate, and enforce communication policies. Audit email communications, at least periodically, to identify problems. Demonstrate faux pas to your people so they understand the risks. And do this as part of the annual reviews, making sure that the policies are reiterated. And finally, teach your people when in doubt, walk down the hall or pick up the phone. Now, the very aspect of emails and electronic media in terms of communications that causes these concerns and dangers also provides fertile ground for discovery. Most courts require parties to agree on a disclosure mechanism early in the case with respect to electronically stored information. Properly gathering an opponent's emails is critical to prosecuting or defending your case. And don't depend upon opposing counsel to make sure that everything is produced. Make sure that you obtain materials in native format versus PDF images. The native format materials are searchable. They contain metadata, which can tell you dates documents were created and edited, and who the contributors were. The use of searchable databases like Relativity make it much easier today to be able to search through and find valuable information in large volumes of electronic data. Sophisticated filters have been developed to help find the smoking guns. In the cases of documents that are not searchable, coding can be used, and there are services that are provided to basically review the documents and provide the important substance of the information so that it can be searched subsequently. There are many document review services available. There's methods that we have developed or that have been developed to protect privileged materials. If you don't have someone on staff, or if the law firm that you're working with does not, hire an expert. It's well worth it. There are also means of accessing social media sites that are not necessarily easily apparent to the unsophisticated user. When you get into subpoenaing third-party providers like Google, Yahoo, and private email services, often special knowledge and experience is necessary to get the materials that you need and want. Obviously, as with everything with litigation, cost considerations are important. To the extent that you can manage these things in-house, that's certainly an option. If not, choose your litigators with an eye towards their technological capabilities and experience. And again, if you do not have a comfort level either with your in-house or your outside attorneys' capabilities, make sure to look into and find outside companies that can be of assistance to you. Electronic communications are here to stay. We can't turn the clock back. Like any new technology, it has had unintended consequences. Educating our people and monitoring our people is key. Protect yourself with respect to the dangers that the technology provides, while also being prepared to exploit the technology to build a better case. Well, at this point, I finished a little early, but that's probably a good thing. I will tell you that if you have any questions with respect to anything that I've said today, email me.